of intimidating the witness or
Okay.
persuading her in some way. That's all.
So Ms. Rockwell, if you would like the victim who is present and whom I can see, and I don't recall whether you swore in or not, but if
I
you
didn't,
would,
Judge.
you what?
I did not.
Okay.
I did not swear her in.
If you or the state would like for the victim to give her feelings as far as the defendant's release is concerned, she has the statutory and other right to do that. And if she wants to do that, I'll certainly hear from her.
Okay. May I swear her in, Judge? Madam, could you raise your right hand, please? And I just need to make sure I can see her. Could you raise your right hand, please? I just don't see her, Judge. Do you solemnly swear or affirm that the testimony that you're going to give in this matter, State of Georgia versus Alexis Gaskins, be the truth, the whole truth, nothing but the truth? So help you God, or do you so affirm?
I swear.
Okay. Madam, state your full name, please, for the record.
Kayla Anderson.
You can
Okay,
put your
and
hand.
I see you. You can put your hand down. Madam, you are appearing on a Zoom hearing on behalf of Alexis Gaskins bond. Is that correct?
Yes.
And you are the victim in this matter? Is that correct?
Yes.
Okay. And the court would be interested in whether or not you object to a bond in this matter.
No, I do not object.
Okay. So are you afraid of her?
No.
Okay. And do you think if the court set conditions like for her to have zero contact with you, or for her to have no violent contact with you, or for her to have only telephone contact with you, do you think that she would abide by those conditions?
Yes.
Okay. That, Judge, that's all I have.
Anything from the state?
Yes, Ms. Anderson, thank you for being here. Do you have any of the unknown male who was at your home that day who shot through his window towards the household that you and your family members were in?
You said, do I have a picture of him?
I said, do you have any fear for your safety with respect to that individual?
Oh, no.
Do you know who that individual is at this point?
No, I just seen him. I think his name Michael, but I don't know him personally.
Nothing else from this state?
And do you, Ms. Anderson, do you know whether Ms. Gaskins knows him?
I assume if he in the car, I don't really know.
Okay, anything else from anyone?
Yes, I mean, I do respect and appreciate Ms. Anderson's statement, but the state is still concerned that she's not intimidated or not scared at the fact that Ms. Gaskins brought this male to her home, forced entry into the home, and subsequently shot. There's not one, but 4 victims in this case. And so we are very concerned with that. As you see, there are 4 aggravated assaults with intent to murder. And we are concerned this is serious, and we would still recommend no bond be issued in this case at this time. Thank you, Judge.
Okay, and the other three victims or alleged victims, Ms. Martin, were people in the house?
Correct, who were also involved in the fight. Yes.
Okay. Was one of them Ms. Anderson's sister or Ms. Gaskin's sister? There's somebody's sister.
My sister.
All of the people were in the home were related to the victim, Ms. Anderson, not Ms. Gaskins.
Okay. Okay. Well, the calendar shows that Ms. Gaskins has been in custody for 22 days. Does that sound about right?
I think so, Judge.
Okay, all right. And I don't know if this is, so when it came up for bond at first appearance, the determination was that that judge couldn't hear it.
Judge, so I don't think when the state takes the position for the court not to, or to not modify the bond, I think it's in front of your honor because I don't think that the first judge could even entertain bond. So I'm asking the court to set a bond. I don't think that it's a matter of whether or not it needs to be modified or not. I think this is our chance to set a bond, and that's what we're here for today, Judge.
I did review Judge Ashley's bond. I'm assuming that I am hearing it, and I don't. Ms. Martin, are these charges within the statute that only a Superior Court judge can grant bond? Because Judge Ashley denied it because he said the defendant is a danger to the community and is likely to intimidate the victim. He did not decline to hear the bond.
Yes, he had the authority to issue a bond, and he decided not to issue a bond based on what he wrote down in the bond order. So we are asking for no modification at this time.
Okay, I'm just curious as to whether I'm hearing, is this one of the charges that only a Superior Court judge can grant bond on?
No.
I didn't think so. Okay. All right.
Then, Judge, I'm not sure why it is in front of your honor. The only thing and that's what threw me, because I've been waiting for it to come up on a different kind of calendar. But initially I was told that it was going to be heard by Judge Schwall. So I think that you're doing the hearings today for Judge Schwall. I would just point out, Judge, that at first appearance, obviously the victim was not present. The victim could not be heard. There was no information regarding who actually regarding her job, regarding her connection to the community, regarding her obviously her. I think the thing that weighs the heaviest, Judge, is the fact that they were in a relationship long enough to where Miss Anderson knows her more than anyone, and Miss Anderson is not concerned with her safety. Now, if the court is so concerned, I would ask the court to set a bond with no contact, zero, and just with the condition that as best possible, that she's interested also in this fella who's gotten her all roped off like this being brought to justice. But I don't know that the fact that they were interested in the trying to find out who this young man was, I don't think that that Alexis's sister contacting Miss Anderson was in any way of a harassing or threatening nature. What she did was send her a picture of this fella so that the authorities could try to identify him. So based on that, I don't want Alexis Gaskin to be penalized because they were trying to find out who has gotten her into all of this trouble.
Whatever the nature of the contact was.
We're going over the same ground.
Right.
Here is my problem, and I don't know how to get over it right now. First of all, there are avenues for protection for both Ms. Anderson and the other victims, and those are not a bad idea on the civil side as far as protective orders are concerned. Right now, I think that the facts of the case and the sort of general confusion presenting just I'm unable to tell that these other victims are not fearful. And certainly ties to the community are good. Intimidation of witnesses, though, I can't, I'm fearful that there may be intimidation, certainly as Judge Ashley noted, bond is denied.
Thank
And
you,
you,
Judge, and that concludes my business for the day. May I please be excused?
and I just want to, Ms. Rockwell, you can certainly work on, as that becomes more clear, certainly this is a, you can ask to be heard again.
Thank you, Judge, and I appreciate it. So what I'll do is I'll try, with all due respect, and obviously we object to the court's finding, but I will try to get in touch with Miss Anderson's help with the other alleged victims and get back with the court.
Okay, thank you very much. You can get back.
Thank you so much.
Okay, thanks.
Bye-bye.
Thank you, Judge.
May I
Thank
be
you.
excused? Thank you,
Amen.
Judge.
Is that it for you, Ms. Martin?
Yes, that is. Thank you.
Thank you. Good to see you. Okay, next is Darian Dupree. Is someone I asked this before, but is
Miss
someone?
Bray, can you
Oh,
see
hey,
me?
Ms. Bray, how are you doing? It's good to see you.
Good to see you.
Okay, Mr. Abadi, are you doing this one?
Yes, Your Honor.
All right. Madam Court Reporter, are you ready?
Yes, right.
Okay, this is the state of Georgia versus Darian Dupree. This is 20 CP 191-157. Today is September the 1st, 2020. This is, I am in courtroom 8A. Our courtroom is open and accessible to the public, staffed by a member of the sheriff's office. I will say that all of us are appearing via the Zoom teleconference platform, including the defendant. This is on today's calendar for a bond hearing before the presiding judge. The presiding judge today is Judge Schwall. I am hearing this calendar on his behalf, but only this calendar. And I don't know if Mr. Abadi wishes to ask any questions about Mr. Dupree's appearance today, but Ms. Bray is appearing on behalf of the defendant. And Mr. Abadi, if you want to ask any questions, you may do so at this time. Otherwise, we can turn it over to Ms. Bray.
Good afternoon, Ms. Bray. I guess just for clarity for the record, you've spoken to your client, Mr. Dupree, and he's waiving his right to physically be present in the courtroom for this bond hearing?
Yes.
Nothing further, Your Honor.
All right, Ms. Bray.
Thank you, Your Honor. Your Honor, you have before you Mr. Darian Dupree. He is a man who was born and raised here in the Metro Atlanta area. All of his family resides here. He is the proud father of a 7-year-old son who is missing him, of course. The calendar reflects he's been in 134 days, but when you actually check Odyssey, today makes 145 days that he has been in Fulton County Jail and not able to be around his son. He is a high school graduate, Your Honor. I see from the other cases, Your Honor takes the time to actually read through the arrest warrants and everything to get an understanding of the facts that are in the case. Through no fault of Mr. Dupree's, he's been in 145 days with no bond on an unindicted case. And of course, it's unindicted based on that COVID-19 pandemic that we're experiencing and the fact that there are no grand juries. And at this point, we don't know when that grand jury process proceeding will take up or begin again. So he's been in over 90 days. Normally, it would have been indicted already, or he definitely would have had a bond already. But we're in the situation that we are in, Your Honor. Mr. Dupree categorically denies that he committed this offense, Your Honor. When I did check on Odyssey, I see where Mr. Dupree last year was arrested for serious offense, and he sat in jail awaiting trial to prove his innocence. 220 something days were taken from him before he had that trial and was found not guilty. Now, unfortunately, he is in a situation where he is fighting for his life. He is fighting for his freedom. And I can't even tell him when he might possibly have a chance to go to trial on this case, or if it's, I can't tell him that, Your Honor. And I do feel sorry for him because he's already had time taken away from him on a case where he was found not guilty by a jury. I did receive through email a document that was purportedly from the sister of the deceased. General in nature, stating that now people in the neighborhood are willing to talk. They're willing to say what they actually saw, what they actually heard, and that it was not Mr. Dupree. I am hoping Your Honor will take that into account and set a bond on Mr. Dupree's charge. Did Your Honor read the warrant? You did skim it? Okay.
Yeah. I read the part where it said that Ms. Ware identified Mr. Dupree as the man who shot her sister.
That's what it says, Your Honor. But if you clearly, well, there's another sentence in here where she's saying Mr. Dupree is walking out of the apartment, exiting the apartment. I guess she has already turned or something. So she does not see the actual shooting. She hears a shot. The sister comes back in and says, he shot me. She didn't say a name. This location is 2909 Campbellton Road. A lot of my cases come from that area. I mean, several apartment complexes there. Deerfield Garden Apartments, the Life at Greenbrier Apartments. There are shootings all the time in this area, Your Honor. And it doesn't really matter what time of the day or night it is. This is an area where there are a lot of shootings. Mr. Dupree is adamant that he did not shoot Miss Morgan. I want Your Honor to take that into account. Okay. And to please set a bond on his case.
Okay, thank you. Mr. Abadi?
Thank you, Judge. We would respectfully request you deny defense counsel's motion for bond at this time. For several reasons, the state would submit to Your Honor that we believe the defendant to be a danger to the people in the community based on the facts and circumstances of this case. I know Your Honor has briefly read the warrant, but it would be the state's contention that on this April 1st, the defendant did shoot and kill Miss Felicia Morgan in front of her sister, who had briefly turned her back, but indicated that as soon as she turned her back, she heard a single gunshot and saw that her sister was lying on the floor. The detectives, upon their response to person shot call, they did find one 9mm shell casing feet away from the victim's body. I'd also bring to the court's attention, we would submit that the defendant is a risk of committing felonies pending trial, as he does have 3 prior felony convictions here out of Fulton County. The first being in 2009, which is 09 SC 81920, which was a burglary out of this county where he received 5 years to serve 60 days, the balance to be probated. The second case, Your Honors, 13 SC 116331, in which the defendant was convicted of participation in gang activity, as well as the possession of cocaine with the intent to distribute. And that occurred on April 28th of 2014, where he, in the non-complex division, did receive 5 years to serve 18 months, with the balance of that being probated. And lastly, Your Honor, he is currently on probation for case number 16 SC 145911, which is also a possession of cocaine with the intent to distribute, where in September of 2016, he did receive 10 years to serve, 2 years with the balance of 8 years to be probated, Your Honor. We'd also submit to the court that he is a risk of intimidating witnesses and the further obstruction of the administration of justice, as the warrant does indicate. Prior to the victim being shot, the victim's sister, Miss Ware, was struck in the face by the defendant, Mr. Dupree, when she attempted to separate their verbal argument. He then pointed a gun and threatened to shoot her, based on her statements that she made to the police. So we would submit to the court that he's a risk of intimidating her if released from the custody of the Fulton County Sheriff's Department at this time. We would respectfully request that bond be denied and the defendant remain in the custody of the Fulton County Sheriff's Department. Nothing further from the state.
Thank you. Anything further, Ms. Bray?
No, Your Honor.
Okay, Ms. Bray, I heard everything you said, and I thought you said it. I thought you said it well, and I thought you said it well. The warrant is not the jury speaking, and this man is presumed innocent. And this man, he was digitally in front of me as a human being. But the circumstances before the court right now are concerning as far as the remaining, and I don't know if the charges, there's just the one charge of murder, so I don't know if there are any charges that may be brought on behalf of the sister or not, but certainly she is a witness, and with the criminal background and the possible intimidation, bond is denied. Thank you.
Thank you, Your Honor.
All right, that brings us, does anybody, Madam Court Reporter, do you need a break? Okay, that brings us to Anthony Jenkins. Are we ready to go? I think we need Ms. Jernigan. Did she come on? Yeah, hey. I cannot hear you, no. You're muted. No, I still can't hear you. Can anybody hear Ms. Jernigan?
No, Your Honor.
Others are in the same boat, Ms. Jernigan.
Can you hear me now?
Now we got you.
Okay.
Yes.
Okay, are we ready to go forward with Mr. Jenkins? And is this Mr. Jenkins, and is this, Mr. Jenkins, is that you, sir?
Yes.
Can you hear? Okay, you can hear us, sir? Okay, thank you. All right, let me begin our record then. This is the state of Georgia versus Anthony Jenkins. This is 20 CP 193367. This case is on today's calendar for a bond hearing. Today is September the 1st, 2020. I am in courtroom 8A. Our courtroom is open to the public. We're staffed by a member of the sheriff's office, and we're fulfilling our obligation to make certain that the public's business is open and accessible to it. Otherwise, everyone is appearing via the Zoom teleconference platform. Mr. Abadi, you may well have questions for Ms. Jernigan with regard to the defendant's presence via Zoom rather than being present in the courtroom. If so, I'm going to turn it over to you at this time.
Good afternoon, Ms. Jernigan.
Good afternoon.
For the record, I just want to make sure that your client, you've spoken to your client, Mr. Jenkins, about his right to be physically present in court in front of the judge for this bond hearing, and he is not required to waive his presence, but he has chosen to do so today for this bond hearing.
That's correct. We had a conversation, I believe, last Monday about that. He does waive his presence physically.
Thank you, Judge. Thank you, Ms. Jernigan.
Thank
All
you.
right, Ms. Jernigan, would you like to proceed?
Thank you, Your Honor. Mr. Jenkins is 23 years old. My understanding is he is a junior at Georgia State University. He was majoring in sports medicine. He works as a foreman for DOT Energy Solutions. It's a civil engineering company. I believe on this call somewhere is possibly his girlfriend, Miss Cassandra Jones, as well as her mother, Miss Sabrina Jones. He does have community ties to the area. If released on bond, he would reside with his mother in Lithia Springs at the address that was provided to pretrial and reported on their report. He is also, Your Honor, a father, or is a father, unfortunately, of a deceased son. This past May, he lost his 2-month-old child. He is still recovering from that very traumatic experience and suffering that devastating loss, I can't imagine. As well, Your Honor, he has medical conditions. He has been diagnosed with sickle cell. He is suffering from that diagnosis here while he's at Fulton County Jail. It has been causing him to feel the last 3 weeks very sick. He is immunocompromised because of his sickle cell diagnosis. He is concerned about the pandemic and the jeopardized position that being in Fulton County Jail currently puts him in, based on his already compromised immune system. He does not feel that he is getting the medical attention that he is needing at this time, based on his incarceration. Your Honor, he does have, according to the pretrial report, and I did speak with Mr. Abadi as well to confirm, it looks like 2 different fraud-related charges out of 2018. I am not aware of anything since 2018, or if there's been any revocations or issues with him abiding by probation's conditions. But it does not appear that he has any prior history involving acts of violence or anything of this nature. I do not believe that if granted a bond that he would be a threat to the community or to others, based on his presumption of innocence. Of course, in this case, this was a friend of his, Mr. Kevin Williams. He is adamantly denying these allegations as they currently are before the court. I do not believe there's any likelihood of him intimidating any witnesses, or that there's any evidence that the state can provide the court to rebut that assumption. There isn't a witness in the case. I do not believe that there's been any contact between Mr. Jenkins and that young man. I'm not even sure that there's been contact as supported by the statements of the witness. It's to be determined whether or not that's been confirmed as far as I am aware. But there's no indication or evidence that he would intimidate anyone while indictment is pending or trial at some point, hopefully, so that he can dispute the charges if they are alleged against him. We would ask the court, based on his lack of violent history, his community ties, and his school and work standings at this point, that the court consider granting a bond not to exceed $60,000.
All right. Mr. Abadi?
Thank you, Judge. We would respectfully request you deny defense counsel's motion for bond at this time. I would submit to the court that the defendant is a danger to people in the community based on the facts and circumstances of this case. It's a case where the victim in this case, Kenneth Rawls, was in town from Florida and had drove in town in his light blue Mitsubishi Eclipse. The detectives on August 7th were dispatched to the incident location off of Campbellton Road, where the decomposing body was found in the trunk of what turned out to be Mr. Rawls' Mitsubishi Eclipse. And Mr. Williams, that's the victim's sister, and I apologize. Mr. Ross is a friend of Mr. Williams, and I got the two names intertwined, so I apologize.
The alleged victim is Kevin Williams, correct?
Correct.
Yes.
Yes, Your Honor.
Thank you.
And Upon an investigation, the detectives were able to pull the video surveillance, and on August 5th, they saw the defendant in this case go up to the Mitsubishi Eclipse, which with gloves and shoe covers, and wipe down the entire inside of the car, and then walk to the front of the complex, and was picked up by a white sedan. They were able to use the LPR systems for vehicle registration identification, and they were able to identify the friend of the defendant, Mr. Turner. At that point, Mr. Turner did admit that he had dropped Mr. Jenkins off at the location and was told to wait for him to return. The officers continued to pull video surveillance, and they were able to see that on August 3rd, 2 days prior to the wiping down of the vehicle with the gloves and the shoe covers, the defendant get out of the driver's side of the Mitsubishi Eclipse and then walk to the front of the apartment complex, to which he came back 2 days later to clean. I'd also submit to the court, the detectives were able to pull the phone records of the defendant. From the phone records, they were able to ping both the victim, Mr. Williams' phone, and the defendant's phone with close proximity on the August 2nd, right before midnight. They were able to track the two devices to the point where at one point they are right on top of each other, where the state would submit they meet for unknown purposes at this time. But it's been said for the purchase or sale of a firearm between the defendant and the victim. Right after their phones are right on top of each other, the victim's phone completely goes off the network as the phone is shut off. The state would submit to the court that the defendant is a risk of committing felonies pending trial, as the state shows that he does have 3 prior felony convictions, 2 out of Fulton County, Your Honor. Both were first offender pleas at the same time in front of Judge Goger. They were 2 separate cases. The defendant did receive, and this was back on November 29th of 2018, 4 years of probation. So he's still on active probation for those cases, as well as he recently was sentenced on a Carroll County case for identification fraud, where he received 10 years probation back at the first of this year on January 14th of 2020. I'd also submit to the court that he does have multiple warrants for failure to appear out of Carroll County, all stemming out of 2019 or from this 2019 case. And I would submit to the court he's also a risk of intimidating witnesses, as his friend, Mr. Turner, did identify him from the video, as well as indicate that he was instructed by the defendant to wait at the front of the complex for him to return on August 5th, and that he had to take care of some business. And then about 15 minutes later, as the video does corroborate, he does return. Nothing further from the state at this time. I know members of the family for Mr. Williams are present, and it's been communicated to me through Miss Dilma that they feel very strongly that the defendant should remain in the custody of the Fulton County Sheriff's Department.
All right. Anything further, Ms. Jernigan?
Just briefly, Your Honor, in regards to Turner being the one that is ultimately the identifier, saying that it's Mr. Jenkins in the video, that it's not a clear video of any individual, that Turner is caught basically by Detective Thomas, and only upon being caught with his identifying, I believe, his vehicle is when all of this is alleged against my client. Just for purposes of credibility, it seems to be that a lot hinges on Mr. Turner's testimony, and I'm not sure that there's not a motive to be less than or more than not to be as forthcoming as maybe the truth would require.
Okay.
We would ask the court to consider a bond.
Okay, thank you very much. And certainly acknowledge that Mr. Jenkins is present, and I'm looking right at him, and these are difficult decisions to make. We're not trying the case. I'm not trying, the evidence that Mr. Abadi has presented, nor the response, but merely the factors that go into determining whether someone is a good bond candidate. In this particular case, primarily because of when the court hears failures to appear, that's kind of an immediate signal that bond, whether it's on a murder case or on a shoplifting case, is a little too risky. And certainly in this particular case with being on probation, the court is going to deny bond. Thank you.
Thank you, Your Honor.
Thank you, Ms. Jernigan.
I believe that concludes my business. I just wanted to confirm Mr. Raffoff is here for position 7 on Patrick Curry. If that's the case, may I be excused?
You certainly may. It's good to see you. Thank you.
Good to see you too. Take care.
All right, everybody, we still going okay? Madam Court Reporter?
Yes, Your Honor.
You doing all right? Mr. Abadi, you've been on all these. You need a any type of break?
No, Your Honor.
Okay,
Thank you.
let's continue. Our next case on the calendar is the state of Georgia versus Patrick Curry. And let me make sure we have Mr. Curry. Is this Mr. Curry? Is that you, sir? All right. Okay. It's good to see you. All right. This is the state of Georgia versus Patrick Curry. This is 20 CP 193316. Today is September the 1st, 2020, and I am in courtroom 8A. Our courtroom is open to the public, with being staffed by members of the Sheriff's Department. The public is certainly always free to watch its business, and that is certainly the case today. All of us otherwise are appearing via the Zoom teleconference platform. And Mr. Abadi, you may have questions for defense counsel in that regard. And this is Mr. Raffoff is representing.
Yes.
All right, Mr. Curry. Mr. Abadi, do you have any questions you would like to ask?
Very quickly, Judge. Good afternoon, Mr. Raffoff. I just want to confirm for the court and the record that you had an opportunity to speak to your client, Mr. Curry, and he is aware that he has a right to be physically present in court for this bond hearing, but he is waiving that right and choosing voluntarily to go forward over Zoom.
Yes, we do waive the right to be present. I have discussed it with him, and he understands that he will participate by Zoom.
Thank you, Judge, and thank you, counsel.
All right, Mr. Raffoff, would you like to proceed?
Yes, Your Honor. Your Honor, I represent Mr. Patrick Curry. He's 19, and this was a murder case that occurred on August the 9th. It's in front of Old Lady Gang Restaurant, where he was with his mother and his 2 younger sisters, and they were waiting to eat. And the victim in this case attempted to armed rob him, and he had a gun and shot him. And I'm here with the mother, and who's Tanisha Curry, and the 2 sisters, who are all eyewitnesses, and who all know what happened. They were up here from Gulfport, Mississippi, because his mother has 2 sisters here and many other relatives in the Atlanta area. And we're asking the court to set bond. Mr. Curry graduated from high school in Gulfport, Mississippi in 2018. He's 19 now. He's worked at Hardee's since he graduated. He intends to go back to a technical school. He has no record whatsoever, no arrest. He would live with his cousin, Amber McGee, at 2447 Britt Lane, Douglasville, Georgia, if he was allowed bond. The victim in this case, we've been able to do a little investigation of him. He has been in prison as recently as 2016. On his own website, on Facebook, he claims to be a member of the Gangster Disciples, a gang. And again, he pulled, as one of the sisters, Mariana can testify, this victim pulled a gun, stuck it in the back of Patrick Curry, and attempted to rob him. He obviously is not a danger to commit other crimes or interfere with the administration of justice. and he'll make his court dates. And the mother's willing to move here too, if that's what it takes. She can move in with in Douglasville. He only made one mistake, and the mother was driving. They drove away from the scene in this case. Now, the victim's gun was found by the police on the sidewalk right near his body. And so we're asking this court to set a reasonable bond for this young man who, again, has never been in trouble. He was in the gifted program in high school. And we just believe he's a good candidate for bond. And as I say, if the court wants to hear from his family, they're all here with me right now.
Mr. Raffoff, one thing I'm a little unclear on is he from is he living in Mississippi, or is he living?
Yes, they're from Mississippi. They were up here visiting her sisters, his aunts. And so they're from Gulfport, Mississippi, but he would stay here if he's granted bond. He doesn't need to go back to Mississippi. He can stay here with his relatives, and that's why I gave the court the address in Douglasville.
Okay. All right. Anything further at this right now?
No, not right now, Your Honor.
Okay, Mr. Abadi?
Yes, Your Honor. We would respectfully request you deny defense counsel's motion for bond. We would submit to the court the defendant is a risk of flight for fleeing this jurisdiction, as it sounds like his closest familial ties are in Gulfport, Mississippi, with his mom and his sister, who he was up visiting his aunts with. We'd also submit to the court he's a risk or danger to the people in the community. From my reading of the summary and from speaking with the detective on this case, my understanding of the facts are a little bit different, as there were eyewitnesses who saw that were unbiased, as they were not friends of the victim or associated with the defendant, did see the defendant and another male approach the victim, get into a verbal exchange, and then the defendant and his unidentified co-conspirator at this time began shooting at the victim. We'd also submit to the court that he is a risk of committing felonies pending trial, as he was arrested on March 13th of this year in Gulfport, Mississippi, for the possession of a controlled substance, in which he was out on bond when this incident occurred. Based upon all of that, Your Honor, I would submit to the court the defendant is not an appropriate candidate for bond at this time. I would just bring to the court's attention that the defendant did, upon his arrest, did speak to the police and explain to the court, or excuse me, to the officer and the detectives, a similar story, that he was defending himself, but never once mentioned that he was with his mom and his sister for dinner. That he was just in an area with friends that he was unfamiliar with, which is why he was armed, Your Honor. Nothing further from the state.
Anything further, Mr. Raffoff?
Yes, Your Honor. His mother's here, and she was with him. She was there when the police arrested him at her sister's house, and she says there's no way that Ms. Patrick Curry has a record. He was not arrested this year or any other time for drugs, and she's here and she can testify. And again, I don't know about these unnamed witnesses. I'm not aware of any other witnesses. I know that Patrick Curry was outside the car with his sister, Mariana. They were together for most of this time. And she had just got back into the car when this occurred.
I should say the pretrial assessment says that he was arrested on March 13th, 2017.
Excuse me, Your Honor. Good afternoon. Shirley Goldman, pretrial. That is an error. That's this year, March 13th of 2020, Your Honor, is what we're showing from the GCIC.
Okay, and that was in Mississippi.
That was by the Gulfport, Mississippi Police Department. Yes, Your Honor.
Okay, and is that case still open?
It doesn't show whether it's open or closed. There's no disposition on the case or on the arrest, only that the arrest date and the charge were listed, Your Honor.
And the charge is controlled substance?
Yes, Your Honor.
All right. Okay, I'm sorry, Mr. Raffoff. I don't know if we cut you off or not, but is
No, you
there?
didn't. You didn't.
Okay, all right. Well, your client has his hand up, Mr. Raffoff, and I don't know if you want him to speak or not.
That's fine if he wants to speak. I don't have any problem at all with that.
Did you want to, Mr. Curry, did you want to say something? You had your hand up. I just wanted to acknowledge that you had.
Yes, ma'am.
Okay.
Go ahead if you want to, Patrick.
Your Honor, I was here visiting my auntie house with my family. I don't have any friends. I don't know no one up here but my family.
Okay. Okay. And Mr. Raffoff, are the mom and the sister who are with you, do they live in Mississippi?
Yes, they do. But the mom's willing to move up here with her sister, move in with her sister or cousin, if that's what it takes to help it dispose of this or to get him a bond. She's right here beside me.
And I don't want to foreclose anyone. I don't want to foreclose a search for the truth. And I don't want anyone to be without hope. Times, and I'm certain that the Fulton County jail is nowhere to be ever, but particularly under these circumstances. And it may be that we just don't know enough about the facts at this time, but I am hearing that there are no ties to the community, with the exception of Mom's very sincere statement that she would move here if she had to, and that there is perhaps family that could look after Mr. Curry. But I think that under the any circumstances, the court would place on a bond in charges of this type. There's not a significant enough tie to the community, therefore bond at this time is denied. Mr. Raffoff, certainly you can petition for reconsideration at some time where we may know more. Thank you.
Honor, that completes my business. May I be excused?
You may.
Thank you, Judge.
The next one is Ms. Jasmine Adams. We ready on that?
Yes, Your Honor.
Okay, just hang on a second. Do we have Ms. Adams? Yes, hey, Ms. Adams. Okay, this is the state of Georgia versus Jasmine Adams. This is 20 CP 192901. And today is September the 1st, 2020. The court is hearing the bond calendar from the jail via the Zoom teleconference platform. I, however, am in courtroom 8A in the Fulton County Courthouse. Our courtroom is open, open to the public, staffed by members of the Sheriff's Department, and anyone who wanted to view these proceedings would have been free to come on into the courtroom. Otherwise, we are all appearing, I think I said already, but we are all appearing via the Zoom teleconference platform, including Ms. Adams. I believe that she is represented in this case by Ms. Eileen Moorman, and I believe Ms. Winfrey is representing the state in this matter. Ms. Winfrey, do you want to ask any questions with regard to Ms. Adams' appearance this afternoon?
Yes, Your Honor, I would. Thank you very much. Ms. Moorman, have you had an opportunity to speak to your client, Ms. Adams, regarding her rights to be present for these proceedings, but have now elected to proceed via Zoom conference instead?
Yes, I have. It's fine.
Okay. And so your client so waives her right to be present?
She does, yes.
Thank you, Ms. Moorman. Thank you, Judge.
Thank you. Ms. Moorman, would you like to proceed?
Yes, Your Honor. Ms. Adams is charged with 1 count of aggravated assault, 2 counts of cruelty to children in the 2nd degree, possession of, I think, a Schedule II, and drugs not in the original container. This incident arose, Ms. Adams waitresses at several nightclubs. The victim in this case was a good friend of hers. They ended up getting into an argument over money. after I believe they did a party. Sorry. They got into an argument over money after they were hired to provide entertainment at a party together. Essentially, Miss Adams went home. The victim in the case was belligerently drunk, was calling Miss Adams, threatening her. She ended up showing up at her house, threatening her. Miss Adams did call the police. The police asked if she did indeed have a weapon. She stated she did. She had a legally owned firearm. After the threatening, it's kind of unclear if there was actually a physical attack. Miss Adams did fire a warning shot. Unfortunately, the ceilings and the walls in her condo are concrete. The victim did end up with a gunshot wound to the stomach. The cruelty to children counts come from Miss Adams has 2 young children, 7 and 9. They were present at her home at this time. And then the drugs in the original.
Those are her children, correct?
They are her children, yes. The drug count, Miss Adams, that is a valid, she has a valid prescription for those. She had a tooth pulled just prior to this incident. And I have got the copy of the prescription just last night. I've been in contact with Amy Ferguson regarding this case, and I did forward that prescription to her last night. Miss Adams is 27 years old. She has absolutely no criminal history. She's been in Georgia for well over 10 years. She's employed full-time as a waitress and also as an EMT. She has 2 small children, like I said, 7 and 9, that are displaced at this time. They are with her mother. I have not spoken to the victim in this case. I was contacted by the victim's sister, who states she was on FaceTime with the victim during this entire incident. She did state that the victim was heavily intoxicated. She did try to convince her not to go to Miss Adams' home. She did advocate for Miss Adams' release. Miss Adams has been in custody for, I believe, 44 days at this point. Like I said, I've been in contact with Miss Amy Ferguson regarding this case. After speaking with her, she was not opposed to a consent bond, but she would not do that without speaking to the victim. She had great difficulty getting in contact with the victim, of which she did ask me to provide her with the victim's sister's contact information. And the sister's name is Kiara Reynolds, which I did. I believe Friday of last week, she did end up speaking with the victim, and Ms. Ferguson did reach out to me and say the victim did end up calling her back. However, it was unclear the victim's position, so she would not consent to a bond at that time. It would like us to move forward with a bond hearing. As far as the flight risk, like I stated, Miss Adams has been a resident of Georgia for well over 10 years. Her children are here with her. They do live with her. She has full custody. She is the sole financial and care provider for those children. Her mother resides here as well. Her sister, her entire family is here in Georgia. A risk to reoffend, absolutely no criminal history. And the only witnesses are Miss Adams' sister was on her FaceTime, and the victim's sister was on the actual victim's FaceTime. Other than that, we're asking for absolutely no contact with the victim. So there's really no threat to the community or likelihood to intimidate any witnesses. So we would ask that a reasonable bond is set for Miss Adams. Like I said, she's been in custody 44 days. We don't want contact with the victim. The victim's sister did inform me that the victim was upset that Miss Adams had not reached out to her since this incident has happened. Miss Adams is not allowed to contact the victim. I don't know that the victim is aware, is aware of that. Prior to this incident, like I said, they were very good friends. So I don't know if she was upset because of that. She hadn't checked on her. The victim has been released from the hospital. She was there but a few days and is doing fine per her sister. So like I said, I would just ask that the court sets a reasonable bond for Miss Adams.
All right, thank you. Ms. Winfrey?
Thank you, Your Honor. At this time, the state would oppose bond. We believe that the defendant is a threat or danger to the community, and we will state that this incident that took place on July 20th of 2020, it took place at the Skyview Apartments on 1080 West Peachtree Street here in Atlanta. The victim, Miss Courtney Reynolds, I'll spell that for the court reporter, Kourtnee Reynolds, Reynolds. They actually have been, Ms. Reynolds and the defendant have both been friends for about 10 years. Actually, Ms. Reynolds was residing in the apartment with the defendant. They were roommates. They both are dancers pretty much at Diamond's nightclub. And when this incident occurred, the defendant actually went home after an event first. She then called the victim, and told her to come get her things out of the house. It was at that time that the victim went to the apartment to move her things out of the apartment. And when they got there, they got into a verbal altercation. We have no indication that it was anything physical. When the victim went to her bedroom to go and get her things, the defendant went to her room and grabbed a weapon. She did shoot that weapon in front of her kids. The two minors one was 9 years old and the other was 6 years of age. When the police arrived, the victim was a little lucid and was able to provide some information. But when she was transported to the hospital, it was found that she had a gunshot wound into her navel that traveled to her thigh. And that bullet is still lodged in the victim's pelvic bone. It had caused damage to her colon and to her intestine. We believe that in this particular case that the defendant is a danger to the community, in that while this was a verbal altercation, the defendant got so upset that she went to grab a weapon and actually shot that weapon and caused permanent damage now to the victim in this case. Ms. Reynolds while she's not on Zoom, she is also watching, decided to watch via the live feed via YouTube. When asked about bond, she did not really want to weigh in on it. The parties, the defendant and the victim they have been friends for a long time. However, this incident has now caused her some irreparable damage. The court would ask that the state would ask the court deny bond based on the reckless behavior exhibited here by the defendant. We believe that poses an issue and seeing that both girls work at the Diamonds nightclub entertainment. Should the court is inclined to grant a bond, we would ask that the defendant not be allowed to go back to that nightclub because they both worked there. That would cause, we think, an issue. And then the victim has requested that should the court grant bond, that she not be allowed to frequent her place of employment, which is the Diamonds nightclub. And so for those reasons, we asked the court to, one, deny bond, but should the court grant bond, that she not be allowed to have any contact with the victim, that she stay away from Diamonds nightclub. The defendant's criminal history shows she has 3 arrest cycles, but no felony convictions. Nothing further from the state.
Your Honor, may I add?
Yes, of course.
The state did give information that the victim and the Miss Adams were roommates. Miss Adams, technically, I guess they were roommates, but Miss Adams actually allowed Miss Reynolds to come live with her because she was put out of her home with her mother due to physical violence to the mother and the brother. And then also the state argues that Miss Adams got so upset that she grabbed a weapon. She wasn't upset, she was in fear. And I think that's a huge difference. The issue with the clubs, there is no issue. They work at more than platinum and more than diamonds. They work at several different clubs. We have no problem staying completely away from the victim at all. If that means that they have to figure out a schedule that they're not at the same club at the same night, that's completely fine.
Okay. I am more than eager to have conversation continuing, Ms. Moorman, with you and Ms. Ferguson, or with you and whomever. The problem is that I do not think that this is one of those cases in which bond could not have been granted when it first came up for bond. And in fact, the judge that did hear this matter back on July 21st found Judge Pope denied bond on the basis that the defendant posed a danger to the victim and to the community. Now, that might have been a perfunctory finding by somebody who had a lot of cases that day and didn't really have time to hear all the facts. I similarly think there's more to learn here. And on that basis, I denied bond.
Okay, Your Honor.
Thank you. All right. Case, unless anyone needs a break, is Tony Miles, and that's Mr. Secret and Mr. Granville and Ms. Warren.
Good afternoon, Your Honor.
All ready to keep going?
Yes, I'm ready to keep going.
Okay, this is the state of Georgia versus Tony Mitchell. This is CP 193160. This case is on for bond hearing. Today is September the 1st, 2020. I am in courtroom 8A. Our courtroom is open and staffed by a member of the Sheriff's Department, and anyone who is to attend today could in fact attend. Otherwise, everyone is appearing via the teleconference platform, including Mr. Miles. And Mr. Miles is that you, sir, Mr. Miles? Mr. Miles does appear to be on the Zoom teleconference with us. He is represented by Mr. Brian Granville and Mr. Secret. And the state is represented by Ms. Winfrey. Ms. Winfrey, at this time, would you like to ask any questions with regard to the defendant's appearance?
Yes, Your Honor. Thank you. Mr. Granville, have you had an opportunity to speak with your client regarding these proceedings and his right to be present, physically present for these proceedings, but has decided to waive his right to appear for this bond hearing?
Yes, and he waives his right to appear for purpose of this bond hearing.
Okay, and I'm sorry, one more question. For purposes of this bond hearing, who will be handling? Is Mr. Granville or Mr. Secret?
I would be the primary person handling it.
Okay, thank you. Thank you, Judge.
Absolutely.
Thank you. Mr. Granville, would you like to proceed?
Yes, ma'am. So just before I begin into my argument, I just want to give the court a little background on the case. This case initially came before the magistrate court for bond during Mr. Miles' first appearance on August 4th, where the bond was denied without the court citing any specific reason. And what I want to make sure I do today is just as a point of clarification for the court, because I'm not sure if the clarity was there during the first appearance, but the offense that my client is charged with is child molestation. This particular offense is a non-aggravated bailable offense, in that Mr. Miles is not being charged with an aggravated child molestation that's prohibited initial bond under section 1664C. I just want to make sure that the court is clear that this is not an aggravated matter. So I just want to make sure you clear that, Your Honor.
Got it. Thank you.
So again, we're here, respectfully requesting bail. It is our hope and expectation that you will indeed agree with us and order bail. For the record, my client denies all the allegations as false and fabricated. Your Honor, Mr. Miles is a 54-year-old military veteran. He's a grandfather with 6 siblings and 4 kids in Georgia. He served this country in the Navy for over 25 years and received an honorable discharge. He's married to Angela Miles, who's present on this Zoom call today. He's been married to Miss Miles for over 18 years and even helped raise her infant daughter. And in fact, Miss Miles told me today that she doesn't know what she's going to do financially, especially during this pandemic, if her husband doesn't receive a bond today. So I just want this court to keep that in consideration. He owns his home. I forwarded Mrs. Woods a copy of the deed earlier prior to this hearing, Your Honor. He owns a home in Fairburn, and he's lived there for the past 16 years. He also owns his own trucking business for the last 13 years, which was incorporated in 2007. I also forwarded Ms. Woods a copy of the Articles of Incorporation. He owns the trucks to the business. He has employees. He's responsible. He's the primary financial provider for his wife and family. He's a productive citizen, military veteran, business owner, homeowner, loving husband, father, grandfather, and as I will go into a little further, he has no prior criminal record. So as such, you know, he's not a flight risk. He's lived in this region throughout his life. He's no danger or threat to any person or property. There's no risk of him committing any felony pending trial. He's only had one arrest in the last 10 years, which was a misdemeanor DUI in which he was acquitted. He has no verdicts or guilty pleas against him. There's no risk of him intimidating. I know that's a grave concern of yours, Your Honor, by listening to all the prior matters before us. But here, this is a special case because there's no risk of him intimidating any witness or obstructing justice because the complaining witness and the alleged victim both reside in the state of Nevada. And and I'll get into that a little more, Your Honor, if you bear with me for a minute. So when you're considering the factors in granting bond, the length and character of Mr. Miles' residence in the community is well documented by being here, for living in his home that he owns for 16 years and being married for 20, well, I think, excuse me, Angela, I know it's not 28 years, 18 years. And Your Honor, we also have 9 letters that have been also submitted in support of him that I also emailed to Ms. Woods of various family members, various community members. In addition to that, Your Honor, I have 5 witnesses on this Zoom call that I'm going to be calling in a few minutes and have them give a very brief testimony as to his mental state, his connections to the community, and his character, if you will, afford me that opportunity, Your Honor. And let me just kind of see, we're kind of getting into the allegations a little. So let me kind of go into that regarding the nature of the charge, if you will, Your Honor. This charge is being brought on by Mr. Miles's daughter, who's claiming that Mr. Miles improperly touched her. It is our contention, and it will be shown at trial, because it's well documented, known within the family, that this daughter is very disgruntled. You know, he would never touch his granddaughter. He's a loving family. If you have an opportunity to read those letters, these are all his brothers and sisters, and all of them have kids the same age as this 4-year-old daughter. There's no prior indication of this whatsoever. The issue is the daughter asked Mr. Miles, she always asks for money, to pay for her daughter's charter school tuition. He refused to do it. Next thing you know, 3 days later, these allegations come up. He's been totally cooperative with the investigators and the police. He's allowed them to come to his home to interview. There's no independent witnesses of this. And in fact, the doctor that was commissioned by the police department and the investigators found that there's no conclusive evidence whether this event happened or not. I'm not privy to any other information. This is just information we've gotten. We haven't received any discovery. And again, obviously this is not something that anyone wants to be charged with, and we don't take the charges or the allegations lightly, but it will be proven that she has a history of making up stories against family members to get attention. So with that being said, Your Honor, I won't go too much farther in that. Respectfully, we believe that Mr. Miles is a good candidate for a reasonable bond. He has no prior history of long established ties to the community. He owns homes here, a home here rather, a business here. So we're asking for a reasonable bond in the sum of $10,000 with conditions, with no contact with his daughter or the alleged victim, with conditions with no contact with any child under the age of 16 without the presence of another adult. And again, Your Honor, and I want to really emphasize, as the Georgia Constitution provides in OCGA section 1761, all offenses are bailable by any court of inquiry except certain offenses. What Mr. Miles is being charged with is not one of those 13 non-bailable offenses as described in the statute. And we believe that the magistrate's denial of the bond for this non-aggravated offense was in error. So if you will, Your Honor, time permitting, I will be extremely brief. I do have some witnesses that I would like to call. I'm going to ask some 5, maybe quick, short, brief questions, if you will, Your Honor. Is that okay?
That is fine. I will say one thing right now, and I hope this is also acceptable with our jail personnel.
Yeah.
We need to take a quick break.
Absolutely, Your Honor.
Everybody needs to just take a moment, and it's 4 o'clock. If we could try to get back about 4:05, is that
Yes,
okay?
ma'am.
All
Yes,
right.
thank you, Your Honor.
Thank y'all very much.
Yes.
Ma'am, come around to the, come around here. Come over here. So sorry. Ready when you are.
You ready, Your Honor?
Yes.
Okay,
Wait just one second. Our
Sure.
court firing back up. And I believe, okay, and I believe, Mr. Granville, you were at the point where you were going to briefly present family members.
I would briefly present some witnesses, Your Honor. I would first like to call Dr. Suzanne Adair. Suzanne, are you on the call?
I am.
Okay. Good afternoon. How are you?
Good. Thank you.
I'm gonna go ahead and swear you in. Will you raise your right hand? Do you swear and affirm to tell the truth, the whole truth, and nothing but the truth before this honorable court today?
I do.
Okay. State your name for the record.
Dr. Suzanne Adair.
And what is your level of education?
I have a PhD in educational theory and policy and a master's of social work.
And what's your occupation?
I'm an associate vice president at Penn State University.
Okay. And how do you know Mr. Miles?
Mr. Miles is married and has been for 18, 19 years to my lifelong best friend.
Okay. If granted a bond, do you believe that Mr. Miles is a flight risk?
Absolutely not.
Okay. Would you be willing to sign the bond if the court requires you to do that to guarantee Mr. Miles's appearance?
Yes, I would.
Do you believe he is a danger or threat to any person or property?
None at all.
Do you believe Mr. Miles will commit a felony pending trial?
Absolutely not.
Do you believe that Mr. Miles will intimidate any witness or obstruct justice?
Absolutely not.
And lastly, would you like to add anything, any personal reference that you have to talk about his character before the court?
Yes, I want to go on record to say that briefly, I could say a lot here about
Yes.
Tony Miles, but this is a man, simply put, of a great deal of integrity. I have seen him over the years. I am close to this family. I've interacted with him, with minors, and he has shown nothing but responsibility, integrity, respect, appropriate interactions, and cares for their well-being at all times.
Okay, thank you. And so my son is a senior at Woodward Academy. He will be applying to Penn State University.
Let me know.
Sorry, thank you very much. I didn't know if Your Honor had any questions.
Not of this witness, no.
Okay.
Your Honor, the state would.
Okay, thank you. Thank you. Sorry.
Ms. Adair, do you know how the defendant's employed?
I'm sorry, say it again.
Yes. Did you know how the defendant is employed?
Yes.
And how is he employed?
He is a driver of his own trucks and he owns a company.
And has he been doing that since your relationship with his wife for the last 18 years?
He has been driving for that time. He has owned his company less time than that, but been driving the entire time.
And in his drive, okay, I'm sorry. And in his driving, does that take him out of the state quite often?
It does.
Okay. Nothing further.
All right, thank you, Doctor. Okay. Any comments?
I would like to call Harold Simmons. Is he on the call? Mr. Simmons?
Who's next? Oh, well, now Harold is down here, but muted and not on video.
I'm not sure if he can hear me. Angela, you may want to try to get Harold on the phone. I'm gonna move on. Let me see who we have left. Is Andre Simmons on the call? Andre, I see you there.
All right, can you hear me now?
Okay.
This is Harold Simmons.
Okay, Harold, how are you? Brian Granville.
I'm doing fine.
Okay, 1 second, let me figure out what am I doing here with my computer. Okay, let me go ahead and swear you in, Harold. Can you raise your right hand?
Hang on, just can
Yes,
Mr.
ma'am.
Simmons turn his video on, please?
Let me see, hold on.
On your left At the bottom left, it should say stop, start, or stop. There you go.
That accepted.
There we go.
Okay.
Okay.
And will you raise your right hand for me, please? Do you swear and affirm to tell the truth, the whole truth, and nothing but the truth before this honorable court?
I do.
Can you state your name for the record?
Yes, sir. My name is Harold Lee Simmons.
And what is your level of education?
I have a bachelor's degree in criminal justice.
And what is your occupation?
I'm a retired law enforcement officer of 30 years. I am currently the city manager for the city of Snoy, and I've served 9 years in the Marine Corps as a military policeman and a drill instructor.
Okay. How do you know Mr. Miles?
He is my youngest brother.
So I would take it you've known him all your life.
I've known him all my life, and I trust him with my life.
Well, you've known him for all of his life. He's your younger
All
brother.
his life. That's yes.
Okay. If Mr. Miles were to receive a bond, do you believe the client would abide by the terms and conditions of the bond?
I do. And the reason I believe that is because even when this allegation came out and the warrant was taken, he had many opportunities to try to talk to the victim or the family. And he knew of the seriousness of this allegation. So he chose not to talk to them without a court order. So I know he would abide by whatever the judge says.
Would you be willing to sign the bond if the court required you to do that to guarantee his appearance, future court dates?
Yes, I would.
And if the bond is granted, do you believe Mr. Miles is a flight risk?
No, he's not.
Do you believe he's a danger or threat to any person or property?
No, he's not.
You believe he will commit a felony pending trial?
No, he's not. No.
Do you believe that he will intimidate your niece or any other victims?
No.
Okay.
And can I say this? I know he owns his own company and he goes out of state, but he has the choice that he can work in state if that's what the judge says. So I hope that him because he has a license to leave the state doesn't mean that he will if the judge says he's not supposed to.
And he also has opportunity to find other gainful employment. Would you agree?
Yes.
That does not consist of driving the truck.
Well, he can have other drivers to go out of the state, but he needs to operate the company.
Okay, so you're saying that he can still operate his trucking business without him even operating a truck or leaving the state?
That is correct.
Okay. If anything else you want to add before this court, feel free.
Yes.
Real brief.
Yes, I'll be brief. Your Honor, if I thought that my brother was a threat or that he would not do what you said, I would not be on this call because of my service and what I hold the value of law enforcement. I would not be standing here today asking you to give him bond if I thought that he would violate it. Thank you, Your Honor.
Thank you. Any questions from the state?
Yes, Your Honor. Mr. Simmons, were you present at your brother, the defendant's home at 1895 Winding Crossing Trail in Fairburn in January 20th of 2020 when this incident arose?
When the police came? No, I was not. I was there when the police interviewed him, but I was not there when it arose, no.
Okay, and so you were present on March the 9th when they came to talk to the defendant, is that correct?
That is correct.
And you were the one who escorted the detective out of the home that day, correct?
That is correct.
Okay, nothing further.
Okay.
Now, Your Honor, I would say add one last thing.
Well, hang on just a second, sir. I understand, and I'm sure you've been in court many times, and you understand that we ask questions and we expect answers, but we're not inclined to just open for statements. So I appreciate your participation today, and I'm sure the defendant does as well.
I understand. Thank you, Your Honor.
Thank you, Your Honor. We can move forward. Is Andre Simmons present?
Yes.
Okay, Andre, please raise your right hand. Do you swear and affirm to tell the truth, the whole truth, and nothing but the truth before this honorable court? You're muted. Can you hear us?
I do.
Okay. State your name for the record.
Andre Simmons,
And what's your level of education?
bachelor's degree in banking and finance at the University of Georgia.
And what is your current occupation?
I'm the associate director of accounts payable and travel for the University of Georgia.
And how do you know Mr. Miles?
He's my uncle.
How long have you known him?
I'll be 42 next week, so almost 42 years.
If Mr. Miles was to receive the bond, do you believe the client would abide by the terms and conditions of the bond?
Definitely.
Would you be willing to sign the bond if the court requires you to do that to guarantee Mr. Miles' appearance?
Yes.
If the bond is granted, do you believe that he'll be a flight risk?
Oh, not at all.
A danger or threat to any person or property?
No.
Commit a felony?
No.
Or intimidate? I guess that would be your cousin.
Yes, that's my first cousin, so no.
Okay, or obstruct justice?
No.
Okay. Is there anything else you would like to add before the judge to take under consideration?
Just the fact that I do have 2 young daughters who have interacted with my uncle, and I have no reason to ever doubt the love or anything inappropriate happening from him while interacting with them. That's for me. Like I said, I have 2 younger daughters. They're a little older than his granddaughter, but at the same time, he's been around them all their life, and I've never had any reason to suspect anything out of Uncle Tony.
Okay. Ms. Winfrey?
No questions, thank you.
Okay. Is Kimberly Holmes available? Is she on the call?
Yes.
You're on the call? I'm trying to find you somewhere where you are. How you doing, Ms. Holmes?
I'm doing good.
Okay. Will you raise your right hand, please? Do you swear and affirm to tell the truth, the whole truth, and nothing but the truth before this honorable court?
I do.
State your name for the record.
Kimberly Holmes.
And what's your level of education?
I have a high school diploma, and I also have a certificate in childhood development associates.
And what is your current occupation?
I am the director at a child care center.
And how do you know Mr. Miles?
He is my uncle. My mother is his sister.
Okay. Okay, so the victim is your first cousin as well?
Yes.
Okay. If Mr. Miles was to receive the bond, do you believe that he would abide by the terms and conditions of the bond?
Yes, I do.
Would you be willing to sign the bond if the court requires you to do that to guarantee his appearance?
Yes, I would.
Do you believe that Mr. Miles is a flight risk if he was granted a bond?
No, I do not.
Do you think he's a danger or threat to any person or property?
No, I do not.
Commit a felony pending trial?
No.
Do you think he would intimidate your cousin and her daughter?
No, I do not.
Or any other witness whatsoever that has any knowledge or personal knowledge in this case, in this matter?
No. No, I do not.
Okay. If you want to say, do you have anything that you want to add to the court for consideration?
I do. My son, I have a son and 2 daughters. My son is almost the exact same age as my Uncle Tony's youngest son. So he has spent a lot of time at my Uncle Tony's house in the past. And I talked with my daughter, my 16-year-old last night, and I asked her, have you ever felt uncomfortable around Uncle Tony? And that was probably one of the worst questions I could have ever asked her. She said never in all of her 16 years, she ever felt any way about Uncle Tony that way. And I will not discuss this with my 12-year-old only because I don't want to cloud her judgment. But I know that she feels the same way about Uncle Tony. My kids do not fear any of their uncles. They've never felt, and I don't get that vibe from him. So this is definitely a shock to me to hear that this was even thought of, could have possibly, there's no way.
We know why it's like that. That'll come out of trial, but I don't have any further questions. Your Honor, do you have any questions?
No, Ms. Winfrey?
Nothing from the judge, thank you.
Thank you, Ms. Winfrey. And last but not least, is Rico Simmons on the call? I don't think I saw his name. Rico is not here.
Yes, I'm here.
Okay. Oh, there you are. I saw you earlier. Nice to see you.
Good to see you too.
Can you raise your right hand, please? Do you swear and affirm to tell the truth, the whole truth, and nothing but the truth before this honorable court?
Yes.
All right. State your name for the record.
Enrico Simmons.
Okay. What's your level of education?
School diploma and some college.
What is your occupation?
I am a lead operator, machine operator at Avery Dennison.
And how are you related to Mr. Miles?
He is my uncle.
So you've known him all your life?
Yes, sir.
And would you be willing to sign the bond if the court required you to do so to guarantee his appearance?
100%.
Do you think he'll be a flight risk or intimidate any witness?
No.
And I guess the witness or the victim is your cousin, your first cousin as well?
Yes.
Okay. Do you want to add anything? I don't have any further questions. Anything you want to add to the court for the judge's consideration?
Yes, I would also like to add with Tony being the youngest, and he's the brother of my mom. So me and Tony have kids the same age. I have a son and I have twin daughters. My twin daughters are the same age as his daughter. Maybe a couple of months, she's a little bit older. And I would just like to say that my kids have spent time at his house, stayed overnight. His kids have spent time at my house, staying overnight, going on trips, and, just enjoying family time. And, with me having girls, you can never be too cautious. So you always asking questions, not just particularly towards a particular person, but just in general between men or, something that could possibly go wrong with your kids. And when I spoke to them about it and let them know what was going on with their Uncle Tony, and I was asking, have they ever been afraid or ever experienced anything that made them uncomfortable? And it was like, Dad, where's this coming from? So 100%, my girls love and would do anything for their uncle, and the same for my son, which is the same age as his son.
Thank you. Thank you for providing that information. Your Honor, so I would just end, and I'm sure Mr. Sequin wants to say so. Yes, Your Honor?
Ms. Winfrey, do you have any questions?
Oh, I'm sorry.
That's okay.
Sorry about that, Ms. Winfrey.
That's okay.
I'm tired, I'm ready to go.
Thank you, Judge. But no, I have no questions for this witness, Judge.
Okay. Mr. Granville, one thing that I have not heard from anyone, and I'm just curious as to who currently lives in Mr. Miles' home.
Sure. His wife, and his wife Angela's on the call as well. It's just he and his wife. Angela, are you on the call still?
Yes, I see her.
Okay. And it's just, I believe it's just, it would be just Mr. Miles and his wife, Your Honor.
Okay.
Living at the residence. But I would like to close. Like I mentioned, the physician's report came back inconclusive. And, we all, my client's presumed innocent. Pretrial services has even recommended bond. There's no prior criminal activity in his life. So again, we respectfully request this court to order bond. With COVID-19 running rapid throughout Fulton County Jail, we fear my client's health worsening. He does have diabetes, high blood pressure, and he was in a life-threatening trucking accident in 2005. He was in the hospital for over a month. So he does have an elevated respiratory issue. And so, his whole family that you spoke of, and again, we have letters from 9 other family members against these allegations, but we'll reserve that when we litigate that at trial. But, we all want him out. We fear his safety and fear him getting sick there. and he is presumed innocent, and he pretty much meets all of the checks all the boxes for the reason why you should be able to award bond in this matter. Mr. Secret, did you want to add something before we close?
No, I'll let Miss McKinney, is it? The prosecutor make her argument, Joe.
Okay.
Okay.
All right. Thank you, Winfrey.
Ms. Winfrey.
I'm sorry.
It's okay. Thank you very much. Your Honor, at this time, the state would oppose bond. We do realize, and I want to put on the record that the court, particularly Judge Glanville on August the 4th, did deny bond in this case and did specifically state that the defendant posed a significant risk of intimidating the victim or otherwise obstructing justice if released on bond. We would agree with that. And we also contend that based on the allegations and based on the nature of the defendant's work, that he poses a significant risk for fleeing the jurisdiction or not returning to court, being specifically that when this case arose in January of 2020, officers tried to reach out, Fairburn Police Department tried to reach out to the defendant in their investigative processes and were basically given the runaround until that March the 9th meeting that Mr. Simmons talked about when he testified, where they went to his house to interview him. They were finally able to get to him on March the 9th, and then detectives were escorted out. But I would like to give the court a little more factual background as to why the state would oppose bond in this case. The victim in this case, and I will refer to her by her initials, she's 4 years of age, and her initials are SC. S as in Sam, C as in Cake or Cody. SC at this time was on January the 20th at the home of the defendant. She was there with her mother, and they were about to leave the home when SC was asked to take some toys back upstairs, or take a toy back upstairs. When she took the toy back upstairs, she went to the restroom. At the time, the defendant followed her upstairs. She came back down and her mother saw that the victim, SC, was digging into her underwear or her vagina area. So her mother took her back upstairs, took her back into the bathroom to see if maybe something was wrong. She didn't wipe properly. And when she went back up there, the victim, SC, disclosed to her that her papa had touched her vagina. At that time, the mother immediately took her back downstairs. When SC went downstairs, she actually stopped and stated to Mr. Miles, said, "Papa, I told Mama you touched me." At that time, they gathered their belongings and they left the house. When they went home, they lived in the Palmetto area. They reached out to law enforcement, so there was an immediate outcry. Reached out to law enforcement. They were instructed to go to Eggleston Hospital, where they went to have an examination done. The victim was subsequently forensically interviewed. And in that forensic interview, she disclosed that she was at the sink washing her hands, just washing her hands. Her underwear were down and that Papa had touched her in her vaginal area. The medical records indicate that she had some kind of abrasion, which was 5 o'clock to her hymen area. Although the doctor did not conclusively say that it was from the touching, that follow-up medical record has not been produced as of yet, and we're still looking into that. But that she did have an abrasion on her vaginal area after this episode. The mother, in this case, the victim's mother, did disclose that there had been some I guess, sexual assault kind of within the family with her that had been shoved up under the rug, and that caused her some concern. They do currently live in Nevada. They did leave Atlanta after this incident because of this incident to kind of stay away from everything. We believe that Mr. Miles does pose a significant risk, danger to children or to minors, and we ask that if the court is inclined to give a bond, that he's not allowed to be around minors in any way whatsoever. We also contend that, again, that he is a flight risk. It took officers quite some time, approximately 2 months, to catch up with the defendant when they wanted to talk to him about this case. And because he has a long haul truck driver, that he drives from state to state to state, that we may have issue with him returning to court. And for that reason, we think he is a flight risk. Again, we know that the bond order that was issued by Judge Glanville said no bond. I have not heard anything in the testimony that there's a change in any kind of circumstance from the date that the initial bond order was issued to today to show that this bond should be modified in any way. And based on those reasons, we ask the court to deny bond.
If you may, Your Honor, may I have a rebuttal to that? First of all, those are all allegations, and everybody that has ever gotten charged with a case that faces a bond issue had allegations that they were facing. This is not the stage to litigate those allegations. Obviously, we think they're false, but those are not what should be considered in determining whether a bond should be issued. The fact of the matter is there are solutions that could be placed, or conditions rather, that could be placed on the bond to make the court more comfortable. We can have an ankle monitor where the clients can't leave his home. You could order him to have home confinement. You could order him not to leave the state, have no contact with the victim, have no contact with any child. But for us to properly prepare a defense, we need to have our client out of jail, because really the fact of the matter is these are just phantom claims. I don't hear any evidence that he's a flight risk. I don't hear any evidence that he has a history of molesting children. In fact, we had 5 witnesses that testified that he has a history of not molesting children. So you have to do a balancing in regards to the parents saying that they spoke to their children and said that they've never had any issues. So, I mean, it's highly questionable, but I'm not going to litigate whether or not, you know, the mother is credible or not, because I didn't know that that was a consideration in regard to determining whether he should be offered a bond so he could be released, so he could prepare a defense. But again, the conditions, special conditions, or combination of conditions you can add on to answer everything, to rebut everything Ms. Winfrey said.
Okay.
Yes, Your Honor.
Can I just make one point for clarification? Just one point for clarification. Ms. Winfrey gave the court the indication that this bond order was signed by Judge Glanville.
I was going to point that out.
And that is not true. It gives the court the impression that it was the Superior Court that in fact issued this bond. It was a magistrate judge at the jail, not Judge Glanville.
It was 100 people on the call.
Sorry, I stand corrected. I see that it was Ashley, and I cannot pronounce the last name.
Right. I was going to point that out, so I appreciate you coming up, because this matter was just heard on August the 4th. It was a judge, I'm going to go with Ghulam Hussaini.
Correct.
Like over 30 days ago, Your Honor, about 29 days ago.
Okay. And I will note that the reason given poses a significant, the reason that there was a bond denial was that the defendant poses a significant risk of intimidating the victim or otherwise obstructing justice if released on bond. Let me say the following. I am granting a bond. The bond will be in the amount of $20,000.
Thank you.
Whoa, wait a minute, I'm not through. It is that can be payable through the sheriff's 10% program. So that's number one, $20,000. Here are the conditions. Number one, the defendant will not reside with anyone under the age of 18. So that he will not reside with anyone under the age of 18. He will not have contact with the victim or the victim's immediate family. Now, I understand that they're all family, but that would mean, you know, the victim's mom, the victim's immediate family, to include mother, father, sisters, brothers, whatever. He will not leave the state. I realize that may impact his income, but I think that is an issue that has arisen. So he will not leave the state. Now, with regard to the general being around children, I think at one point, Mr. Granville had said something about, you know, he won't interact with children under 16 unless there's an adult present. I mean, I've not heard, other than the obvious charge at issue, that has ever been any type of issue. Does anybody want to speak to that particular condition?
I do, Your Honor. I think in these types of cases where the disclosure, most of the time in these cases, disclosure is delayed. And most of the time, 80% of these cases, the victim never comes forward and says anything. And I think that when you have issues with even allegations of child molestation, it's important that there's a special condition that they not be around children for the safety of the community, for the safety of any other minors. And I think that should be something that should be absolutely placed in your, as a special condition of bond.
All right, well then I'll go with what Mr. Granville said, which is will not interact with children 16 or under without an adult present.
Thank you, Your Honor.
Okay, Ms. Winfrey, I know I'm not asking you to agree, but is that the type language you were discussing?
That's just right, Judge. Yes, yes.
All right, and I don't know, frankly, at this point, who prepares the bond? Is it someone from Judge Schwall's office? Okay, Ms. Woods, thank you.
Your Honor.
Yes.
I need to have, this is pretrial, Shirley Gordon. I need for the defendant to have the defendant's email address as well as his phone number. The 10% program is, as you know, supervised by pretrial.
Correct.
Also, I need to know, did you have a level of supervision in mind?
Let me ask you, the defendant may want to, the 10% program is essentially a benefit to the defendant. And I've had many defendants come back and say, leave me alone, I just want to go through a bonding company. So that's sort of up to the defendant. If there is a reporting, I would put it at level 1,
yes,
which
Your Honor.
is the least. I look it up every single time, Ms. Gordon, and I think it's the least.
It is, Your Honor.
And what does level 1 require, Ms. Gordon?
Level 1, the defendant reports once a month.
Okay. And did you want that email, that other information? Can we email that?
If you could put it in the chat room for me.
All right.
And
okay.
Also, it needs to be listed on the bond order. Someone from pretrial will contact the defendant. We are not having in-person orientation right now. The orientation will be conducted over the phone.
Yes,
that's why I need his information. Thank you.
Okay, just hear that. Ms. Gordon, are you confident enough that we can move on to our last case?
Absolutely, Your Honor.
Gordon, thank you.
Thank you, Your Honor.
All right, thank you, everyone. Thank you, Ms. Winfrey.
May I be dismissed, Your Honor?
Brian, you need to stay on so that you can email.
I'm going to do that.
Okay, yes.
All right, Mr. Granville, Mr. Secret doesn't want you getting on.
I know, I'm going to do that. I'm getting that together now, Mr. Secret.
All right, thank
you. Do what you're told, and we're going
to. Yes, I will.
All right, our last case, and for those of you who have waited patiently, I think we've got a camera out at Metro, and now we have Ms. Singleton who's been hanging in now, unless we've driven you off, Ms. Singleton.
No, I'm hanging in here, Your Honor. We're ready.
Okay. Mr. Jones, sorry about this.
Judge, I'd like to announce I have 12 witnesses.
Fast as Judge Schwall. But let's get to Mr. Mathis. So if are you ready, Madam Court Reporter?
Now you're funny. I just want to.
Okay. All right. This is the state of Georgia versus Hakeem Mathis. And this is 20 CP 193 No, I'm giving the wrong case number. I apologize. This is the state of Georgia versus Hakeem Mathis, which is 20 CP 193636. Apologize for that. Representing Mr. Mathis today is Mr. David Jones, and I don't know who is representing the state. Ms. Winfrey, you still with us?
I'm still with you, Judge.
All right. And Ms. Winfrey is representing the state. Do you believe that Mr. Mathis is on camera? So today is September the 1st, 2020. I am in courtroom 8A. Our courtroom is open to the public. staffed by a member of the Sheriff's Department. We have ensured that the public has its business open and accessible to it. And otherwise, everyone is appearing via the Zoom teleconference platform, including the defendant, Mr. Mathis. I'm going to ask Ms. Winfrey on behalf of the state if she has any questions of Mr. Jones or anyone regarding his waiver about his otherwise right to be personally in court this afternoon. Ms. Winfrey?
Yes, Judge, thank you. Mr. Jones, have you had an opportunity to speak to your client regarding his right to be present for these proceedings and that he is so waiving that right today to proceed with this bond hearing?
Yes, I have, and he is waiting.
Thank you, Mr. Jones. Thank you, Your Honor.
All right, Mr. Jones, would you like to proceed?
Judge, and I promise to be brief.
Mr. Jones, you take the time you need. I realize everyone has been very patient this afternoon.
Judge, Hakeem Mathis is currently, or he's right now 15 years old. He would have been, or would be this fall, entering the 9th grade. Last year he attended Carver High, but his grandmother tells me that he's ready to be enrolled at Langston Hughes High School. I wasn't able to get any of his transcripts, but his grandmother reports to me that basically he's an average student. He's on track to be in the correct grade for his age. He does participate in sports, football. He did work a summer job at a Chinese restaurant on Simpson Road. He worked that summer job, and this is last summer, Judge, for a month. Obviously, there's not many summer jobs available this year. Judge, the incident, and also, he has no prior juvenile history. He has lived here all of his life. His grandmother has had him since he was 2 years old. He resides with his grandmother. The address is 107 Summerwood Drive. That's in Fairburn. Judge, the alleged incident, or the incident is alleged to have happened in March 17th, approximately, of this year. The allegation is that the charge is rape and child molestation. The allegation is a sexual violation of his 10-year-old cousin. He at the time was 14. Judge, the allegation surfaced immediately. The police were called. They interviewed my client, and then they left. He was arrested last week on these charges. And during that time, between March 17th and when he was arrested, he had no contact with the victim or the victim's mother. There is another child residing at the residence. It's actually my client's 10-year-old sister. There's no allegations involving her. Judge, my client denies that there was any penetration or that there was any rape. He made that statement to the police, it's my understanding, and that's my investigation of the case. I know Ms. Singleton has interviewed him, and I believe he qualifies for their supervision. I understand that the court might want to put him on a house arrest, which is fine. He just needs to go to school, and if he is ever lucky enough to get a job in the next few months, to go to work. But I would ask that the court grant him a bond and that he reside with his grandmother. Her name is Brenda Gates. Judge, I know she was going to try to get on, but I don't think she has been able to. But I've been in constant contact.
I'm on.
Oh,
Yeah.
Hello, Brenda.
Hi. I don't know why I can't see myself. I see you. I'm here. I'm at work, but I'm here.
Okay, very good. Is there, well, let me ask Brenda to raise her right hand.
Oh, we can't
see that. That's right.
I don't know why I can't. Let me see if I can start the video. Okay, there it is. Okay, there it is.
Okay.
Go ahead, Mr.
And Brenda, will you raise your right hand?
Yes,
Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Okay. You can put your hand down, dear. Is it correct that Hakeem will reside with you if the court grants him bond?
Yes,
Will you see to it that he complies with all and any conditions that the court might impose?
absolutely.
That's all the questions I have, Judge.
All right, Ms. Winfrey, any questions?
Yes. Good afternoon, Ms. Gates.
Good afternoon.
Ms. Gates, your address you provided, can you provide that for me again?
107 Summerwood Drive, Fairburn, Georgia 30213.
Okay. And so you don't live at the address where this happened at 595 Malin Avenue. Is that right?
That is his, no, I don't. That's
where
his mom's.
Okay.
That's his mom. But I am his legal guardian.
Correct. I understand that, Ms. Gates. But his mother, Tierra Gates, he frequents her residence from time to time. Is that right?
Sometimes, yes.
Okay. All right. And other children live in that residence?
His sisters and brothers.
Okay. And he has a sister that's about 10 years old that lives there?
Yes, he does.
Okay. That's all I have.
Okay, just so I can clarify, when you say lives there, Ms. Gates, does the 10-year-old sister live with you?
No, she lives with her mom.
Okay, so the only child who lives with you
is Hakeem.
Mr. Mathis.
That's correct.
Does anybody else live in your house?
My boyfriend.
Okay. All right. Okay, thank you. I don't have anything else, if anybody. Mr. Jones, do you have anything further of Ms. Gates?
No, not of Ms. Gates, Your Honor.
Okay, anything further?
Judge, I would just ask that you, well, I'm sure you're going to talk to Ms. Singleton.
I am.
Ask that a bond be set through her program.
Could I please say something? Hello?
Yes, ma'am. What do you want to say, Ms. Gates?
I would like to say that Hakeem is the only child at home with me. He doesn't go anywhere anyway. He's a home child. And he was a latchkey child because I work with special needs children, well, adults, I'm sorry. My mind is really going right now, but there is no risk of him being around any of our family members. Since this incident, we haven't even been around no one. I've changed my whole complete life. I'm a grandmother of 15 grandchildren. And even with this granddaughter, this is hurting me because she is my granddaughter, but I have to be with Hakeem. I don't want to hurt either of my grandkids, but at this point, I have to be with him. And I just need you to know that he doesn't go anywhere. He's not a partying type kid. He's quiet. He stands off to himself. So he's definitely not going to be a flight risk because he can't go nowhere without me.
Are you going to be home? You say you work, that he was a latchkey kid. Are you going to be home?
Well, if I have to make arrangements for that, and I've already put that in place for someone, if I need 24-hour supervision, then I will make that arrangement, which I have already talked with my son about doing that with me, helping me out there.
Okay, thank you.
Mm-hmm.
All right, Ms. Winfrey, would you like to proceed?
Yes, Judge, thank you very much. The state does have some concern about this case, and actually this is an unfortunate case because the defendant is 15-year-olds and the victim, I refer to her by her initials as KM. She was actually 8 years old at the time that these allegations arose. Specifically, March of this year, they were actually at 595 Malin Avenue in Atlanta. That is where the defendant's mother resides when this act occurred. Okay, so when this act occurred, another kid walked in on the defendant humping KM. Her clothes, her panties were down. I think his clothes may have been on. Then the disclosure came out, and that's when KM talked about how this actually started spring break of 2019 was the first sexual act that the defendant committed against her while they were in the bed together he actually inserted his penis into her vagina once. After that, she mentioned that the next incident was at Christmas break, where he actually bent her over and inserted his penis into her vagina during that incident. And then now you have this incident where they're at the mother's residence at 595 Malin Avenue, and he's humping her. When KM was forensically interviewed, she disclosed these incidences and how this happened 3 different times. But what's also concerning for the state is that she disclosed that Hakeem, or the defendant, told her that he'd been doing the same thing with his little sister, who actually lives with the mother, who's 9 years old. I refer to her initials as KC. When officers tried to investigate that part of this case to get some cooperation, to get her forensically interviewed, that has not been something that's materialized. And that causes us concern, because I'm sure the mother, who is the defendant's mother, is concerned about her children and about them getting in trouble. And because there's a potential second victim, we believe the defendant poses a significant risk or a danger to other children and other young girls, unfortunately. The defendant actually told KM, the victim, the named victim in this case, that told her not to tell anyone, that if she told anyone, that they would both be in trouble. And that is why she did not disclose. They were actually caught, and that's how the disclosure came out. So the state is concerned about, the fact that there is a potential second victim in this case that we're still investigating. Also, at risk for intimidating witness may be an issue. The family, I think, has kind of been trying to keep this kind of covered up, not really assisting with the investigation of this process. Again, because these are the young kids, this is their family, they want to protect them, but that's not gonna protect our victims or any other young person in this case. Those are our concerns for this case, Your Honor, and that there are 3 separate incidences where Mr. Bridges, the defendant, I'm sorry, not Mr. Bridges, Mr. Mathis in this case has sexually assaulted this 9-year-old victim. And now there's a potential for him doing something similar to his sister. And we believe that that's an issue that the court should consider when considering bond in this case. The mother has not necessarily been cooperative, so we're not sure if him going and living with Ms. Gates, that's something that can really be something that we can shore up, that he will not be around his sister or some other young female child while out on, if he was to be released on bond. So for those reasons, Your Honor, we're going to ask that he not be provided a bond in this case. We will corroborate what Mr. Jones has said. He does not have any juvenile criminal history from what we've seen. Only thing that we see are his custody type issues, that, guardianship issues that he's undergone with being with his grandmother, Ms. Gates. But I'm not sure how that supervision is going there, because these incidences happened while she had legal guardianship of him. So for those reasons, Your Honor, we ask you to consider that our contentions here and not give bond.
Thank you. Ms.
May
Singleton?
I respond briefly?
No, hang on. Let's hear from Ms. Singleton, if you don't mind.
Yes, Your Honor. I have spoken with Brenda Gates, and I have spoken with Hakeem Mathis as well. I did speak with Ms. Gates about supervision in her home. She explained to me that she does work long hours and sometimes pulls double shifts. Her boyfriend, who lives in the home, also works hours where there would be long periods of time where the defendant would have been home alone, especially with virtual learning being in place. So she did speak with her son, and I have spoken with him, Kwan Gates, who I believe is on this Zoom as well. That is her son, and he stated he works the night shift, and so he would get off work and come to the home and stay there if the court were to grant a bond with Hakeem until one of the other adults in the home came. I did explain to
Mr. Kwan Gates.
That I did not ask him, Your Honor. He has his own residence, but he is on here.
Okay. Ms. Gates or Mr. Kawan Gates, if you could tell me how old he is. Ms. Brenda Gates, how old is Kawan Gates? I can't hear you, ma'am. You have to unmute your. Ms. Gates, we cannot hear you.
Okay, I said he's 31.
Okay, and he's your brother?
He's my son.
He's your son, okay. Okay, thanks. All right, Ms. Singleton, I'm sorry, getting back to you.
That's okay. But I did speak with him about the supervision if he were to be granted a bond and be the person that would be responsible for him until his mother or her boyfriend came home. Ms. Gates did tell me that there are no children in the home. She did explain about the latchkey situation, as I stated, Your Honor, but I told her that the court we would need 24-hour supervision for sure. So that's how her son, Mr. Gates, came into the picture. I did explain to both of them the type of bond conditions that he would likely receive if granted a bond, which would include a no contact with children, either under 13 or 16, which are the standard ages. So just depending on what the court would like to see. I was also made aware by Ms. Gates that there are family members. Apparently they live in a duplex type of situation. So there are also other family members to the right and to the left. I did not inquire as to the ages or anything, but I did explain to her that he would not be able to go anywhere. I know I heard her say a little while ago that he would only be with her, go with her, but he cannot go anywhere. He would re-enroll in Langston Hughes, which is the school in her district. He was at Carver because they had tried a situation apparently where he lived with his mother for a period of time. It sounds like it was around 3 or 4 months from November to March. And then that did not work out. So he did return back to his grandmother's home. While he was at his mother's home is when he attended Carver. So he would just re-enroll in Langston Hughes at this point. And I believe that is all. He does not have any juvenile history, Your Honor.
Ms. Singleton, what about ankle monitor?
Oh, yes, definitely, Your Honor. I would request that if he were granted a bond, that he receive the ankle monitor. It would be free, paid by the Department of Juvenile Justice, and that he receive the wraparound counseling services as well.
And under the wrap, and I was going to ask about the wraparound. Under the wraparound, is that in-home visits?
It is, Your Honor. They will visit with him, and they have still been visiting. Most of the agencies that I use, it's between 3, have still been visiting in the home, and they visit multiple times a week and report back. They're all pop-up visits, and then report back to me.
Okay. And then Ms. Singleton, are you the one, or is someone in your office actually looking at the ankle monitor reports?
I'm the one looking at the ankle monitor reports as well as the monitoring company. And so the ankle monitoring alerts come to my cell phone as well as my laptop.
Okay. All right, so we would be looking at a signature bond in this case?
Yes, Your Honor, a signature bond or 10%.
Okay. Ms. Winfrey, do you want to weigh in on that at all?
Again, I guess my concern is the supervision. I know that Ms. Singleton mentioned that he'd been at a couple of schools, one based on the address that where the incident occurred, I believe, with his mother. Just want to make sure that if there's a no contact provision, that it's a no contact with the siblings, because that's a concern for the state based on the allegations that were made by the alleged victim in this case, and also by the defendants on admission to her about what happened with his younger sister. That would be one of our bigger concerns, Judge. And I'm not sure if the court can do this, but I mean, is Ms. Singleton, can y'all schedule some kind of psychosexual evaluations of this, of the defendant at this point? That would be helpful.
That would be his lawyer. That would have to schedule that.
I'll look into that, but that can't be a condition.
Right, I gotcha.
Okay. Well, here's what I'm willing to do, and this is in familiarity. What about with his mother? I mean, My tendency would be no contact with his mom, but maybe telephone.
I would agree with that, Judge.
And Judge, I can tell you that he has an estranged relationship with his mother. So telephone contact and limited to that.
Okay. Well, here's what I'm willing to do. I'm willing to go through the signature bond program. And Ms. Woods, I hope you're with me on this, but it would be secured by an amount. In other words, he would be able to go through, it would be $25,000 on the rape and $10,000 on the child molestation, but he could go through the pretrial program. And but if that's somehow counter to the Ms. Singleton's program, you need to let me know. Otherwise, the standard conditions that I'm aware of through the juvenile bonds are that he have an ankle monitor, that he have a 24-hour curfew except for school, if he does get a job, and legal and medical, that he have the wraparound services, that he have no contact with children. I'm going to go with 15 since he's 15. Children under 15. That he re-enroll at Langston Hughes and remain in school. That's going to be part of his bond. That he do well enough disciplinary reasons and academically, that he remain in school, that he have no contact with his siblings, with the victim, that he certainly not go to their house, but he's only allowed out of the Summerwood address for the reasons stated, which are school, work, legal, and medical, and that he can only have contact with his own mother via telephone. Is there anything else, anything that I'm missing, or and Ms. Woods, anything that I haven't been clear on that you need clarification?
Not right now, Judge. If I do, I'll call Ms. Singleton to make sure that I have the wording correct for DJJ, excuse me. It's been a minute. For DJJ.
Yeah, she's already got her family brain on.
It is.
Is there anything else? Now, Mr. Mathis, I don't think I need to tell you that these are very serious charges. This is a very limited opportunity to not be in custody. And when I say very limited, you may think that judges are harsh, or people in the jail system is harsh, but you don't know Ms. Singleton. Try putting one over on her and see what happens to you, because you will be back in so fast it won't even be funny unless you do every single thing that she tells you to do. Then this is your opportunity. And I realize that you're presumed innocent and these are only charges, but they're very serious charges. I mean, this could only be heard by a superior court judge. So I'm encouraging you, no matter what you think of anyone involved in this system or anything else, to do what we tell you to do. This is your chance. Ms. Winfrey, is there anything else?
I just wanted to be clear on the amounts, Judge. I think I missed when you mentioned how much per count.
$25,000 on the rape and $10,000 on the child molestation.
Okay, thank you, Judge. That's all.
And that is a SOB through pretrial services.
Yes.
Ms. Singleton, did we need to get the same information that Ms. Gordon needed in the previous case, or is that something that you will handle yourself? Like the address where he's going to be residing, who he's going to be residing with, phone number, email address. Okay, so you can send all of that to me.
Yes.
And just for the record, he will be living with Ms. Brenda Gates at 107 Summerwood Drive, Fairburn, Georgia 30213. And I didn't say, and I'm glad y'all brought this to my attention, he is to be supervised at all times by an adult, whether that is Mr. Kawan Gates or Ms. Brenda Gates or Ms. Brenda Gates' boyfriend.
Yes, Your Honor. And he will have no contact with children under 15 except at school.
Fair point.
All right. Thank you, Your Honor.
Okay, anything further?
Not on behalf of Mr. Mathis, Judge.
Okay.
Not on behalf
What's
of the
the
state.
boyfriend's name?
I'm sorry.
What's the boyfriend's name?
What's the boyfriend's name?
Brenda, you still there?
She is, but
Yeah.
she's muted.
I don't know why I'm muted, but yes, his name is Raymond Russell. And I had a question about that.
What is it, ma'am?
Because Raymond works, he's pretty much like a contractor of his own work. So even with that, you're saying he can't leave out the house, but there are no children on his job. And he's also stated that he's willing, if need be, to take him to work with him daily. Is that a condition that we could consider? No, in the house?
Yes, ma'am.
Okay, that's fine.
And if there is another candidate to be with him, let Ms. Singleton know. We're not trying to create undue obstacles. The best thing you've got to protect yourself is a telephone before something happens, not after something happens. So just call Ms. Singleton.
Understood.
Okay, great. All right, well, everybody, a little bit longer. Judge Schwall, staff, thank you so much. No wonder he's so successful.
Thank you, Judge. We appreciate it.
Good to see you, April.
Good to see you, April.
You too, Deborah, Miss Winfrey. I miss y'all.
You too.
I miss this.
Okay.
Thanks,
Well,
Judge. Have a good evening.
thank you,
Thank you,
everybody.
Judge.
Okay, thank you.
Good night.
Right.